we will demonstrate. So there's no amusement here. After 30 years of a distinguished career, double board certified, the highest ethical ratings, never having had any accusation of this sort other than from this lawyer right here who makes these ending remarks about how this is so painful for him. It's not amusing. And let me tell you, this motion is outrageous. And we do intend to file a motion for sanctions under Rule 13 for the court to punish them for this dilatory tactic. One point I would like to make to the court right here is if you read cases about disqualification of attorneys, the appellate courts, including the Texas Supreme Court, emphasize to the trial judges, watch out. Danger, danger. Motions to disqualify attorneys are the perfect grounds, the perfect tool of someone seeking a dilatory tactic. That's what you have here. The single most infamous litigant in the United States of America for dilatory tactics is the Church of Scientology and all of its corporations. If you look at our initial response, which we put together very quickly, we have some materials in there concerning the history of this church's attack on judges, witnesses, lawyers, parties. Now, their complaint, and you notice they never get really specific about what is this highly confidential material that was released by these lawyers in some great unethical act. Let me tell you this, Your Honor. Every word in that affidavit of Mr. Rathbun, which we were forced to file because of Mr. Miscavige, Captain Miscavige's false affidavit, saying he didn't have any connection with the state of Texas. He didn't even know Monty Drake, who had worked for him for 15 years. We had to get proof of the contacts with Texas. So, did I receive, Your Honor, some confidential, privileged information from Mr. Rathbun that went into that affidavit? Everything in that affidavit I already knew. Your Honor, it is all in the public domain. Every single word. And what is so disgraceful about this motion is that they know it. You heard yesterday that just of Mr. Rathbun's writings, they have 25 or is it 27 big 3-ring binders of every word he's ever written. The stuff in our affidavit, this is a best-selling book published just this past year by Pulitzer Prize-winning author Lawrence Wright. The one that kind of started it all, the first really true outside history of the Church of Scientology by Janet Reitman, called Inside Scientology. All the stuff I was talking about yesterday, the Guardian's office and how things operate, it's all in these books. By the way, Mr. Rathbun, and we'll offer all of these, Your Honor, in the course of this hearing. Memoirs of a Scientology Warrior, the Scientology Reformation, What is Wrong with Scientology, with a picture of the Squirrel Busters that you saw yesterday on the cover. It's all in the public domain. Well, what about the best I can tell from their motion is that, gosh, if you look at paragraphs, was it 61 through 65, I think it is, where Mr. Rathbun talks about having hired on behalf of Mr. Miscavige the Jenkins and Gilchrist law firm in Texas. Nothing in there says anything about what was said. He's not quoting anybody or Joe lawyer said this to me. But he describes his contacts on behalf of Mr. Miscavige in the state of Texas. Guess what, Your Honor? As they well know, that was the subject of Mr. Rathbun's examination under oath in a Florida federal case last year. The exact topic in greater detail. It was filed in federal court in Florida. Mr. Rathbun, by the way, isn't a part of that case. He was subpoenaed, and he appeared, and he gave his examination under oath. In fact, he tried to resist it. The exact thing that Mr. Spencer has manufactured this outrage about was filed in federal court last year. It is attached to our supplemental response that the court has. It is their burden to show that this, first of all, that this information is privileged or confidential. All of this information, when it came to little old me, was already in the public domain, and I was familiar with it. I've read Reitman's book. I've read Lawrence Wright's book. I had read the examination under oath of Mr. Rathbun, which is on the internet. If they had merely Googled a few simple searches, they would see that everything that they're so shocked about is out there. How is that confidential? So, number one, the evidence that they're crying about is not privileged or confidential. It's in the public domain. Number two, as the court is well aware, waiver is a gigantic issue when it comes to matters of confidentiality and privilege, because the whole concept of confidentiality and privilege is, the overarching concern is we need to keep this secret information close to our vest. We don't want the world to know about it. Mr. Rathbun spoke out for the first time in 2009. He has spoken out in the media. He has given print and television interviews. He's written 3 books. He's been the subject of a documentary. He has been called as a witness or listed as a witness in numerous cases, including all 3 of the cases Mr. Spencer has been involved with. And guess what, Your Honor? Never once, ever, from coast to coast, they have over a dozen lawyers in this courtroom. That's how lawyered up these people are. Never have they sought a protective order, a gag order. Have they sued Mr. Rathbun when he's listed as a witness? They don't go and seek some kind of a protective order saying, oh my goodness, we cannot have this confidential, privileged information get out into the public domain. No, it is a consistent strategy in every case. They know that Mr. Rathbun is one of the most knowledgeable human beings in the world about what's going on or what has gone on in the Church of Scientology. And that he would very likely come up as a witness to the extent that the practices and procedures of the church come into bear in some litigation. And when he's listed as a witness, or he gives a declaration, or an affidavit, or an examination under oath, they don't claim privilege. They don't go to the court and say, the court, don't allow him to testify about this. It's all top secret. Why? Because it would be ridiculous. It is all out there in the public domain. That is waiver. To be surrounded by dozens of lawyers and to review they're watching him like a hawk. That's why they have every word he's ever written in 27 3-ring binders. They watch him like a hawk. They video him. They do all of these things. They know, and they've never once taken any action to shut him up. Instead, they have this very clever dilatory tactic. Anytime an attorney seeks assistance from Mr. Rathbun, we'll just get the attorneys disqualified. There aren't too many attorneys willing to take on the Church of Scientology. They have filed motions to disqualify over and over and over again. That's the situation that we're in. That's why we're going to come back here and ask for punishment against them. What is another basis for waiver recognized by the law? And that is offensive use of the privilege. That's exactly what they've done here. They've come here and asked you for the ultimate relief in this case. For Mr. Miscavige, Captain Miscavige, and the RTC, dismiss us from the case. And Mr. Spencer very cleverly just said a moment ago, oh, well, gosh, Mr. Miscavige's attorney yesterday said, we respect the right of Mrs. Rathbun to sue us out in California. Look at his special appearance. It says this is nothing more than extortion. Your Honor, this is how they operate. I am an ethical, upstanding attorney. No information came to me that was privileged, and I decided in some sneaky, immoral, unethical way to throw that out there. This is information that I already knew from public sources, well aware of it, and that's one of the things the court is supposed to look at, is look at the attorney's behavior. I knew all this stuff, Your Honor. To make an offensive use of the privilege, that is, to come to court and say, Your Honor, we want you to do something for us. Dismiss us from this case. We don't want to appear and answer these very serious charges in Texas. And here is the sworn affidavit of the president of RTC and the captain of the Sea Organization and the Pope of Scientology. Here they are. Don't question, don't offer any information in response that shows that these affidavits are false, these declarations are false. That is an offensive use of the privilege. Again, if we get back to the purpose of the whole law surrounding privilege is to keep concealed, properly concealed and concealable things, secrets, is to keep them secret. For the last 5 years, they have made zero effort to keep any of this stuff secret. Why? Because they know they can't. Instead, we have a dilatory tactic, which is, okay, this stuff's already out there, everybody knows about it, but we're going to attack the lawyers in every case. First, attack the lawyers. That's where we stand with this thing. One last thing I would like to caution the court, and we can argue about the law later on these cases, is Mr. Spencer pounding his fist and saying that the law is clear and this is what it stands for does not make it so. He cites 3 white horse cases that he tells you means you must throw these lawyers out of this case. You know what all those cases are? The classic situation of a paralegal works at a law firm on one side of a lawsuit. Sometime later, the paralegal goes over and works for the law firm on the other side of the lawsuit, which, by the way, you can do. You have to have precautions and screens and firewalls. That is not remotely what we're talking about here. That's a person, that would be like if we were 6 months down the road and Alan Cartwright over there, the director of legal affairs for the Church of Scientology International, if he showed up in my office and said, I'd like to go to work with you on this case as a paralegal, and I want to work on this case. Well, if I did that, I'd be an idiot.